Hello, kia ora, tēnā koe, which is the language of the Indigenous people of New Zealand. I'm delighted to be able to address you today, and I'm sorry that it's a pre-record, but we've got all of the problems that are happening at the moment at the conference venue, so it's a shame we're online. Can I acknowledge Professor Livia Holden? Can I acknowledge you're an expert, and my colleagues, Dr. Victoria McLeod and Justice Emilios Kiru, who'll be speaking after me. So the gist of my presentation is the increasing need for cultural experts in New Zealand courts. So New Zealand's unique demography with a large Indigenous Maori population and a national population which is increasingly super diverse means that New Zealand courts need more assistance from cultural experts if, quote, the common law is to serve all in society, close quote, as our Chief Justice recently said in our top court, the Supreme Court. So the paper that I've drafted, which I don't have time to read today because it's half an hour and I've only been given 15 minutes, analyses two cases, Ellis and another case called Dingan Zing, which demonstrate the increasing need for cultural experts in New Zealand courts to determine what the law is, how it applies, as well as to ensure equal access to justice despite cultural and linguistic diversity. The greatest need for cultural experts arises from the majority of the Supreme Court's acceptance that Tikanga, so that is Maori customs and practices, Maori being the Indigenous peoples of New Zealand, was the first law of Aotearoa New Zealand. Otherwise, there is only ad hoc incorporation of Tikanga and of the Treaty of Waitangi, which is the treaty that was signed between the British who came and colonised New Zealand and the Indigenous peoples of Aotearoa. And they are otherwise scattered throughout various statutes, and there's no entrenchment in a supreme constitution, as in the Canadian situation. So lawyers and judges need to acquire a base level of cultural competency to be able to identify when a deeper level of cultural expertise is needed, and cultural experts need to be called on to provide evidence to assist the court. This is important not only to ensure that justice is done in particular cases, but to maintain broader constitutional legitimacy, which will be undermined if significant cultural differences are not acknowledged and in appropriate cases reflected in the application and in the development of the common law. Pluralism is an important value to fill the gaps in the common law created by new situations that Indigenous and super diverse cultures and language often give rise to. So if we look now in some more detail about the uniqueness of New Zealand's demography, which is pushing New Zealand courts to the forefront of jurisprudence on culture and the law, it really is the case that in Auckland in particular, which is our only city by OECD standards, 1 in 3 are already Asian. We have a significant Indigenous population, 17.4% throughout New Zealand and growing. But Auckland is also the biggest Pacifica city in the world, and actually by 2040, which will be the 200th anniversary of the Treaty of Waitangi, what you'll find is that we've got a majority of minorities, or 50% of the population will be Asian, it'll be Pacifica, and also it will be Indigenous. So what does this mean in terms of the incorporation of culture and the law? What does this mean for cultural experts? Well, what it means is that cultural experts have never been so critical to ensuring justice in New Zealand, particularly in the Ellis case, where the Supreme Court majority found that tikanga is the first law of New Zealand. And so that case was actually a procedural decision whether to allow Peter Ellis, who was not Maori, an appeal against sex abuse, child sex abuse convictions to continue despite his death. Now, the Ellis case is one of New Zealand's most enduring legal controversies. and it arose in the broader context of the worldwide satanic panic of the late 1980s, early 1990s. And there, the Supreme Court allowed the appeal to continue in the interests of justice, and the substantive decision quashed Mr. Ellis's convictions, finding that there were problems with the evidence of the main prosecution witness, which was a psychiatrist, and that the jury had not been fairly informed of the risk of contamination of the children's evidence. However, the significance of this procedural decision for our conference today is the decision given by the court to the relevance of tikanga. This was not a case where tikanga arose as part of the context or subject matter of the underlying litigation. As I said, Mr. Ellis wasn't Maori, and actually tikanga only became an issue after it was raised by Justice Glazebrook, who was sitting on the bench in the Court of Appeal once it became clear that the appeal would have to be heard posthumously. So it's interesting that once again, even though we don't have a system, an inquisitorial system, as in some jurisdictions, including the French system, that we have an adversarial system. Nevertheless, we are finding that a lot of these cultural issues are being raised by judges themselves. Now, you're going to ask, what is tikanga? Well, tikanga is a body of Maori customs and practices, part of which is properly described as custom law. And so this causes real issues when we have a situation where the court is being asked to adjudicate on whether tikanga as the first law applies. So here in this particular case, they ended up having to convene really a wānanga or a grouping of experts in tikanga to help them understand what the foundational notions of tikanga are, to assist them to be able to determine whether or not tikanga applied. So even though tikanga is a normative system, it's embedded in the lived experience of Maori, the majority in Ellis accepted that tikanga was the first law of Aotearoa New Zealand, and therefore it continues to shape and regulate the lives of Maori. So if tikanga is relevant to the development of the common law, then it's really important that we are able to access experts in tikanga to be able to adduce what it is, so that we are applying it correctly. The Chief Justice said, tikanga is fluid, it's not fixed, but changes and evolves across time to meet new situations. What is right in any situation may need to be discussed and negotiated between those expert in tikanga, and this is echoed by the Supreme Court's later description of tikanga as an adaptable framework for resolution after finding the lower court's approach to be rigid. So what does all of this mean for lawyers and for judges in New Zealand? Well, it means that counsel in the first instance, lawyers, counsel, need to be able to put a tikanga lens on legal issues and consider whether the tikanga is relevant. Now, that's from a tikanga as a first law, but also from a whether it's relevant in terms of the application of culture and language perspective to what was done, what was said, what was intended, and to credibility. So they need to be able to ask and to answer the question, is tikanga a source of rights and interests? Lawyers will need assistance from cultural experts to determine that, and if so, how tikanga would apply. Judges adjudicating may be equally dependent. Now, this is going to be really difficult because we have experts telling us that you can't properly understand tikanga unless you understand Te Reo Māori. Te Reo Māori is the language of the native peoples. And we have experts saying that despite the fact that they are Maori and they've studied Te Reo Māori and they've studied tikanga all their lives, they hardly understand tikanga. So the challenge is all there for the profession. and for the judiciary to have enough cultural capability and understanding of Te Reo Māori to truly understand, and therefore to be able to properly adduce and apply tikanga. This is exacerbated by the fact that many Maori clients have become alienated from their lands and culture and are themselves unfamiliar with tikanga as a consequence of the devastating impact of colonisation. Those are all in quote marks. Those are taken from the cases. However, in Ellis's case, the Supreme Court took seriously the concerns of experts in tikanga, who said that tikanga Māori might be misappropriated. It might be wrongly applied in the court system. The Supreme Court acknowledged that courts must not exceed their function when engaging with tikanga, that it's not the role of the courts, according to the Chief Justice, to pronounce on or develop the content of tikanga. Those who are sources of tikanga or experts on it will be external to the court. This recognises that Māori have sovereignty over how tikanga is interpreted. Accordingly, you'll find that there will be considerable reliance on experts on tikanga and culture. This cultural expertise will be based on experience rather than acquired through formal education or professional qualifications. Because with Māori, a lot of it is called mātauranga Māori. It is maybe sacred. It is information that's passed on down through the generations, down through the genealogy, down through the whakapapa, the ancestry, and it's done orally. So without cultural experts in tikanga to assist them, the courts would not be able to adapt tikanga to new circumstances confronting them. As envisaged by Justice Joe Williams, he is a Maori judge, he is on our Supreme Court, when he described tikanga as an adaptable framework for resolution. Many of the issues that arise for the court's determination will, as he said, quote, inhabit the grey area between cultural and legal worlds, requiring understanding and the ability to comprehend nuance. Now, there's one final thing to say, that the judges also said that not only do you need to be an expert in tikanga, but you need to understand that in order to determine what tikanga applies, you may need to adopt a tikanga approach. So, of course, a tikanga approach, once again, requires tikanga experts to be involved in determining what that approach should be. I really want to end by saying that even if you're not Indigenous and you are super diverse in the sense that you've come from, you were born in another country and you immigrated to New Zealand, and you may be first or subsequent dingenerations, then the Supreme Court has also provided some guidance in a case called Dingan Zing. And what they've said is that it's important to understand that it will be appropriate, when it is appropriate to introduce social and cultural evidence. The courts have said, 1, it's open to witnesses to explain their own conduct and relationships with reference to their own social and cultural background. This may be supported by expert evidence or reference to sources of information of unquestionable accuracy or reliable published documents. Where a litigant wishes to explain the conduct of another party, such evidence is likely best provided by an expert or by reference to sources of information of unquestionable accuracy or reliable published documents. Now, of course, the court also sounded some important notes of caution, and the main one is against stereotyping. It's also important to note that in New Zealand we have had a lot of problems with cases where deponents have turned up without any expert evidence, and there are cases where judges have simply thrown the case out and said that they are not disposed to Google their way to trying to find whether or not, for example, dowry payments are a customary practice of the Chinese culture. That was a case called Dingan Zing. So can I just say, in conclusion, that of course it's for lawyers counsel to raise issues and to bring the expert evidence. Courts, of course, can also ask questions, including whether expert evidence would be helpful, and they can also appoint an expert to help the court. But in New Zealand right now, there is nothing more hot and relevant than this global symposium on cultural experts in the courts. It's timely for us because Indigenous and super diverse populations are expanding in our country, but they're also expanding in a growing number of countries around the world. And there is recognition of their rights and interests and the role of Indigenous customs and practices as the first law of nations. And so as that happens, cultural expertise will be needed to explain what was said, what was done, but also to assist courts in determining how to adapt the common law so that it evolves, so that it fills the gaps that are created by the new situation thrown up by people who are Indigenous or of a different culture and language. This is essential to ensure equal access to justice. It is also essential to ensure and to maintain constitutional legitimacy more broadly in countries like New Zealand, where we are no longer a homogeneous population, where we have people from many countries around the world. And of course, the courts are there to protect all people. So without the value and the expertise that can be brought by cultural and linguistic experts, it will be incredibly difficult for the courts to ensure that they are ensuring that all people are protected by the courts and by the common law. Thank you.